So this week, sit down with Angelo Spyratos,
If you're not communicating with your client, they assume that something bad has happened.
one of the founders and managing partners of a large civil litigation firm.
They think that something is going wrong. They fill in the emptiness or the lack of information with drama.
He has over 33 years of experience in the courtroom. We go over how to communicate with clients. We understand a masterclass of how to prepare a doctor for a fraud case.
I'll tell you about a doctor I represented one time. Very smart man. He was being sued. He was very nervous. He was always defensive. He never listened. We're getting ready for trial. I said to him, "Doctor, listen to what I said. I didn't ask that question. Stop giving me information that I didn't ask for." Finally looked at me across the table and said, "I think I understand you. You just want me to sit down and shut up." I said, "Exactly."
Hey, Angelo, how are you?
Good. Good morning.
Good morning.
Nice to see you.
I was just admiring your office, and you were just saying that you have two offices. So if you want to talk a little bit about your office, and then we'll get into the actual meat of the webinar.
Sure. Thank you. My name is Angelo Spyratos. I'm the managing partner at Spyratos Davis, located in Lisle and Chicago, Illinois. Our firm practices exclusively, up until recently, exclusively in litigation. A lot of my work has been bodily injury defense. I'm hired by insurance companies and companies to defend their interests when they get sued in the Chicago, Northern Illinois area, and they are being sued for damages. I've been doing that for 33 years. Our firm is approximately 13 attorneys, and we do, other than that type of work, we also do family law work, corporate litigation, anything that gets you in front of a tribunal where you have to adjudicate your case before a panel, a court, a jury.
So for 33 years, so that's some miles in terms of your experience. There have obviously been highs, there have been some lows. So a question that comes up is what happens during the lows when you're hit with, let's say, a loss or multiple losses, if you will? And then what do you do?
A good lawyer refocuses their client on what constitutes a loss and what doesn't constitute a loss, right? So I say that with a little bit of tongue in cheek. But for example, I represent insurance companies. So if we were to try a case where there's a limit to the policy that the insurance company will cover and the verdict goes above that number, I think that's a loss. That's a loss, unless, of course, we've been telling the insurance company all along, you shouldn't be trying this case. You really should take this opportunity and settle it if there's an opportunity. If they ignore our advice and the verdict comes in higher than what they wrote a policy for, I think that's a loss. Mm-hmm. Also, I guess some other people would say that a high verdict is a loss. And I've had verdicts against my clients, for over $1 million over my career. But, when they asked the jury for $6.5 million, and when at the mediation 2 months earlier, they asked for $3.5 million, and we came close to offering $1 million before the case went to trial. I guess technically, if you read the verdict reporter, it says that there's a verdict against my client for $1 million, but that was well within the area of risk that we assessed. So, but to answer your question, lawyers are competitive. Lawyers, sometimes I don't like to use the sports analogy too much, but a lot of us are kind of, there's, this practice area, there's, if you're in contract work, if you're in corporate work, you help your client, you give advice, they write documents, and you hope that those documents never have to be enforced in a court of law. That you just have them and it's a security, and sometimes they do. But in our job, there is a win and loss. There's nothing like that feeling when you're waiting for a jury to deliberate and your client's case is in their hands and you've done all you could. So you do see it that way, and people say, is it a win or loss? But it depends. If, as an attorney, and this is the answer to your question, if the attorney has put together a solid strategy a plan, their client was on board with the plan, and there's consensus with the plan, and you execute the plan, irrespective of the outcome. If you do that, by the way, overwhelmingly, you're going to get a good outcome. You're going to get the outcome that is consistent with your plan. Every once in a while, some statistics I've read say you just can't control 1 out of 10 cases. About as much as you prepare and get ready, there's 1 in 10 chance that the case goes completely sideways. Um, so if you've been communicating with your client, if you've set the reserves, if you've done all that, and the verdict comes out, even if it's not optimal, I guess that, and it's a loss. You're disappointed on a personal level because you think, did the jury not like me? Did I do something to offend them? But then you go on, especially if there are attorneys on this call who are new to the practice of law, you say, oh my God, I've only been an attorney for a couple of years and I've got this horrible outcome. But really, your client values your time, values your expertise, your effort. So it's not really a loss. So you feel bad for yourself, but then after a couple of days, you go back and you see what you could learn from it, and you talk to your client. If your client's been on board, they're not ecstatic, but they do understand and they want you to do well. So it doesn't last very long. Neither does a victory. So here's the reality: the losses and the victory, the feeling you get when you win a case overwhelmingly, is also not as long as as losing a case. So when you're in your low, you gotta have faith that if you're doing good work for your client, you're gonna overcome it. If a client only gives you 1 case to try and you lose and they never use you again, that's probably not a client you wanted to be in business with anyway, especially if you make the effort. And the other corollary I'll add to this, a way to get your client on board, and it doesn't happen anymore as much as it did earlier in my career. If a client ever wants to come, like especially if you represent corporate clients, and they may not testify, but if a representative of your client wants to come and sit in the courtroom while you try a case, assuming that the people here are competent attorneys, let them come, invite them. Once they see the effort that you make on their behalf and on their company's behalf, or even on individual family members, if they want to come and watch you try a case for an individual, let them come. Because once they see the effort you make, how you fight for them, the knowledge that you have, they're not really going to care about the outcome. They're not going to hold it against you if it doesn't turn optimal. The good news is that overwhelmingly, if you're prepared, you will get the outcome that you expected, or within the range of the outcome that you expected.
Got it. It's said like a true lawyer. It depends, right? Like
it does depend.
Get a lawyer to tell me a yes or no answer, that would be the day.
Well, Syed, it's only the practice of law. It's not life and death. At least not in again, I do civil work. It could be life and death if you're a criminal attorney, but it's really not life and death. I mean, it really impacts people's lives, and we take it very seriously, and we want to protect our clients, and we want to be their champions in a very difficult time. But you go back and you hope that you have your health, and you do the best that you can, and you make the effort, and good things will happen.
Got it. Yeah. This goes back to another thing that comes up, right? Like, which is, expectations from a client perspective. If you want to touch a little bit on that, like, how do you know that you going back now all those years and looking at yourself now, how do you deal with setting up client expectations? Like, hey, this is what I think is going to happen. This is like the extremes, I guess, of what could happen, and then keeping them updated, because obviously in a lot of cases you may be on retainer. So how do you know you've been successful at that? Not litigation, but managing your client's expectation versus at the beginning of your career versus now. Like, how do you kind of gauge yourself or your team like being successful?
I understand. So let me say this. As I've gone on in my career, I really understand better now than I did when I was a newer attorney how to set client expectations and how to not just tell them about what the outcome might be. And this isn't a science. You can't guarantee an outcome, but you're trying to set expectations as to the outcome, the length of time their matter is going to take, and then also what it's going to cost them. So those are the three areas of expectation that I think you have to address. And so I had a client one time, and we were helping them with a zoning dispute that they had with he ran a business and he was asking for some zoning variances. And I went in and I told him, because it was a political process. It wasn't, it involved having to deal with politicians and getting approval and being in front of a city board who are all elected. And, and that's an area that I've done, but I tell you, it is so different than being in a courtroom. Courtroom is logic, applying the law, facts, rules of evidence. In a political process, it's a mess. But so we were helping him with that issue with his local municipality, who was trying to get him to tear down a structure that he had built. And I kept saying to him, the problem with that is this, and the problem with that is this, and the problem with that is that. And he said to me, you keep telling me what the problems are all the time. Why don't you tell me what the solution is? And, and I knew this guy pretty well. So I was like, you know what? He makes a very good point, because we lawyers are risk averse. Mm-hmm. So we are always telling him what can go wrong. But mm-hmm. that's not the way to set your client's expectations. You have to tell them the strategy you're going to use to try to achieve their outcome. And you have to be realistic about the costs. You have to sit down. I have lawyers in my office all the time. I say, you need to write out a cost estimate or a budget for the client. They say, well, I've never done this before. I say, well, sit down and think about what it's going to take. If this happens versus if that happens, and how long, how many hours, how many times do you have to go to court, how many motions you have to bring. Try to figure out as much of that as you can. And then say, it's not perfect, it's subject. So that's setting expectation. And if you communicate with the client on that, and they know what they're in for, then they can make a determination. See, somebody told me once that if you're not communicating with your client, they assume that something bad is happening. Mm-hmm. They think that something is going wrong. They fill in the emptiness or the lack of information with drama. They fill it in with things like, this must be something terrible happening, or even worse, my lawyer's not doing anything for me. Yes. So that's why I say you got to talk to them about the cost. You got to talk to them about the potential outcome and how likely it is to achieve that outcome. And then you have to talk to them about the time it's going to take, right? And then the other expectation might be, you might want to set expectations about how often does the client want to be communicated. Some clients want more, some want less, and you have to gauge that. And now, and the one thing I would also tell you is that do not be afraid. Engage your client in the discussion of fees, because that's one, in my opinion, when somebody comes to you and they want to hire you, that's not a professional, corporation that litigates all the time. They're worried about how this is going to affect them. And you need to kind of understand that that's a concern for them, and you need to set their expectations. And look, and the lawyers are afraid that if I say this and it turns out to be more, they're not going to want to pay me more. Well, I said, I get that, but what you got to do is you got to figure out that, say, look, this is what we think will happen. Now, things may become different, and then when things are different because of some ruling by the court, some outcome, some witness disappears, or you need to hire a particular expert to participate in the case, you should try and anticipate that. But if that changes, then that's, a lot of my clients say, we want to hear about significant developments. Those are significant developments. And when you tell them that, you need to tell them the impact that might have on their fees and the cost of the litigation. So communication is the key. You've got to be aware of it from day one. And then last but not least, and maybe this should have been first, you got to listen to your client. You got to understand and figure out what's their pain, what's their issue, what do they need help with, and where are they mad? Are they offended when they come into you? Are they pursuing maybe a business partner that they are on bad terms now, or think they've been betrayed? Those are all some of the emotions that come into litigation that we as lawyers are supposed to be a little bit more neutral. They're supposed to be a little more trying to seek objective in our assessments. Those are my comments on that.
Thank you. So I think the biggest takeaway for me is whatever is not filled in, people fill it with whatever worse that could happen. Like, I totally agree with that. This happened with me. And I guess even if you go to like a medical office, as an example, and there's something that, the doctor's working on, and you expect something from them. The other thing that you mentioned, which is, and they don't communicate with you on a regular basis, then you'd be like, hey, this person's not doing anything, and maybe they aren't actually. I'm not saying doctors are not doing anything, but I'm just saying in that particular instance. And then the second thing I think is asking like, this is something I haven't done, but I think this is an important one, is asking the client how they want to be communicated with. I think that is a key, like, I think that's a golden nugget right there, because some people may not want maybe multiple reports. They're like, hey, just give me, I don't know, a voice memo or something. Just explain it to me. I'll be in my car. I'll just listen to it. I'll be good. Some people want to read reports, I guess. I mean, or something like, hey, this is what we did. This is the research we've been doing. These are the witnesses we spoke to, blah, blah, blah. Okay, we're happy. Whatever. It depends, right? Like, so I think that's a really key point there that people can take from that. Going off of this now, like, once you, let's say, set expectations, now let's talk about more on expert witnesses, right? They may be expert witnesses and you prepare them, right? If you want to talk about that. But what if what you've prepared them with, and because a lot of these people are very knowledgeable, they want to, how shall I say this? They want to be very impartial with their knowledge. And even though you may prepare them one way or the other, when they go to court, you have a game plan, like, hey, this is the type of question you're going to get asked. This is how you want to answer it. This is probably not how you want to answer it, but it starts going sideways. Like, the expert testimony starts becoming so vague, or it starts going on the other side, like the opposing counsel side. Like, how do you deal with that kind of, has that ever happened to you? Or, and if so, what do you do? What do you do?
So, the advantage of having been an attorney as long as I have is that there seems to be an anecdote that addresses all of these issues. And I'll tell you about a doctor I represented one time, very smart man. He was being sued, and I was defending him. And he was a very good guy, good man, good doctor, very experienced, but he was very nervous. And his nervousness kind of showed itself by being very defensive. And I figured the more that, and he hadn't really done anything wrong. It wasn't really his fault. And so when I was preparing him for trial, he was, again, as I'd known him for 3 years at this point, he was always defensive. He never listened. He always wanted to explain his situation, how the system was wrong and how he was being wronged. And I'm like, that's not going to play well. And then, so as we're getting ready for trial, I said to him, I said, doctor, I said, you gotta listen to what I said. I didn't ask that question. Stop giving me information that I didn't ask for. If you do this, the jury's going to hate you. They're not going to do this. They're not going to do that. And then after and I guess I was a little heated and a little emotional when I told him, you're not listening. This is during the preparation. He finally looked at me across the table and said, I think I understand you. You just want me to sit down and shut up. I said, exactly. Let me do the heavy lifting. And he said that. He was older than I was, but I said, you hired me to represent you. Let me do my job. And by the way, we won that case because I said, you got to answer yes or no, maybe, yes, 20 feet. I saw it. I didn't see it. I did this. I didn't do that. Just very simple answers. And that's what he did. And I think he was much more likable. Now, regarding experts, that's the other point. Experts are usually brilliant people, doctors, engineers, chemists, economists, and they're not. And so I always use the 80-20 rule. Those of us who are advanced professionals, have advanced professional degrees, that's probably approximately 20% of the population, just to use round. And I don't have this backed up. So 20% of people, very intellectual. They read the New York Times. They're happy to process 7-paragraph, single-spaced information. Well, guess what? That's not who's sitting on your jury. So what I try to take control of the situation is, it's the old analogy, doctor, they don't want to know how the clock was built. They just want to know what time it is. Trust me. So I incorporate in my preparation that. Now, what happens if a witness goes off script? I interrupt them. I put up my hand and I say, Mr. Jones or Mrs. Smith, hold on for a second. And then I get very specific with my question. So you said, and I repeat the question that they said, or sorry, I ask a question to underscore a point that is important to the testimony. So, for example, I always like to distill witnesses down to either 3 or 5 main points. And then I let them explain the points. But as long as those points are made, I try to get them back to, and I tell them what that is. If it's my witness, I say, these are the 3 points that I want you to say. For example, that if I'm representing somebody in a construction accident, maybe I want the safety expert to say, the ladder that was used on the job site wasn't rated properly. Number 2, the contractor should have picked that up and should not allow it on the premises. And number 3, maybe the carpenter should have known not to use that ladder. So if those are my points that I want the safety expert to address, then I remind him of that or her. And then I say, I'll say, so you have the opinion that the ladder that was used on the job site that created the accident should not have been used. And he said, and then he'll say yes. And then I'll say, well, why is that? What is it about the ladder that made it unsafe at the job site? So I really try to simplify it. And I do not think, I know it's discourteous to interrupt people, but you have to be in control of your courtroom and your environment. You got to do it. Otherwise, a jury, they will not listen. They will fall asleep. They will look away. And an expert wants to say, but let me explain to you the metallurgy behind, the metal that was used to make this ladder more sturdy than the one that was being used. And nobody cares about that. Nobody really, unless you have another engineer on the site. So you've got to say, hold on for a second. I'll give you a chance. But let me, let me see if I can get you back. And you as the lawyer have to understand the science, have to understand the opinions and the testimony, and you have to be able to say it back in a very simple format. You can't just understand it. You have to relate it simply so that the 12 ladies and gentlemen on the jury can listen to what is being testified to in a way that they understand it, internalize it, and it becomes part of your case.
Do you get that, like maybe watching too many TV shows, but like leading the witness? Do you get that? Like if you start
all the time, all the time. And as a matter of fact, good lawyers lead witnesses, but not usually on key points. So like for example, I mean, for those of you who do trial advocacy, you'd say, Mr. Jones, please introduce yourself. You live at this area with your wife and your 3 children, and this is what you do for a living, and So you might want to, you would actually move a case along on preliminary things if you lead them. You should not, if you're putting on a witness, you should not lead a witness through the important pieces of the testimony. Once the important pieces of the testimony are you elicit that, and you should avoid leading that. But then go back and explain it. So you said this is your opinion. Let me understand how you got to that. Now, what did you review? And then they'll tell you. And then try to have like a discussion back and forth. What about this? What about what documents did you review? And which witnesses did you take into account? Tell me about the calculation you made to conclude this. Okay, so now, doctor, I don't know. And then you can even say to the jury, doctor, now I don't understand the calculation. Oh, it's simple physics. Well, help me understand what you're taking into account, because I'm not an expert in physics. I'm not a medical doctor. Help me understand the medicine or the chemistry necessary to get this outcome. And if they do that, the jury is kind of following along. And then the other thing is the use of exhibits and audio visuals. You break up the testimony, and the way you make a witness stay on track is by using exhibits. So, because we're more, again, 80-20 rule, 80% of the population is going to be visual. They're going to want to see what they're talking about in the form of a diagram, in a picture, in a map, something that they can look at. And by the way, neuroscientists tell you that when you introduce audio visual during the testimony of a witness, it resets people's attention span.
Wow, that's interesting. So I think what I got from this is you're basically a good storyteller. You use different ways of story. In this case, you're not leading, in a way, you are leading them to a conclusion. You're just you're going through like a treasure hunt, if you will. Like in my mind, that's how I think. Like treasure hunt. Okay, you got this. Okay, now you need to get the next piece. You got that. Now you. So in your mind, do you kind of play that out? Like, hey,
Absolutely.
this is one piece. You got that. Now let's go to this piece now.
Well, so part of my job is to mentor some of the new attorneys that we have at my firm who maybe don't have the experiences that I have. And one of the things that I always talk about every day is I talk about what's your theory of the case and what's your narrative? What's the story you're going to tell? And, as human beings, I use the analogy of, given my background, I talk about Homer's Odyssey or Homer's Iliad. And nobody really sat down and wrote it down early on. That was a spoken, one of the great works of Western literature, Western history is the Iliad and the Odyssey. And that was, first of all, it may have been sung, but it was told in the form of maybe a story that evolved over time. Some studies suggest that it wasn't a book that they wrote the way novelists write today. And why was it so popular? Because other than touching on themes that appeal to humanity and to the human condition, greed, power, nobility, it also told it in a story that was easy to follow, and people would just kind of go around the Mediterranean and tell that story. That is so powerful for us as human beings. We want to hear the story, and you want the outcome. And you also said something else, Syed, that is really important. The lawyers will tell me the conclusions. I said, no, I don't want you to tell the jury the conclusion. You got to know what the conclusion is, but you've got to give me all of the facts that will allow them to think that they thought of the conclusion. Like you said, solving a puzzle, like Sherlock Holmes. You give them one bit of information, you give them a second bit of information. Aha, this must be what happened. And they feel like they're engaged in trying to solve a puzzle. You may have suggested an outcome, but you give them the facts, and then they're putting together the pieces. And at the end of the outcome, they say, this is what happened. And instead of you telling them that, you might tell them subtly, but they feel as though they've accomplished something and they've figured it out. And if you do your job right, you will have success in the outcome of your cases.
That is awesome. Yeah, I think another quick analogy is like if you want a horse to drink, you can always salt their oats, right? So
Yeah,
you can make
like that.
you can
That's
make
good.
sure that they will be drinking water after that. Not that I've tried anything like this, but this is what I hear. So
Is
anyway.
that a Texas thing, Syed? Is that something that you talk about? I'm writing that down. I might use that in one of my cases. All right.
All right, so let's reset a little bit. Another popular question is now, if somebody comes to you, when is it then litigation is let's say, is a feasible option versus not, right? Like sometimes I think you may have answered a little bit of this. So in your opinion, when do you feel you want to lean towards litigation versus not? And then the other question, maybe a part of this question, if you want to talk about a little bit, is when do you feel like a lot of people say, hey, I want to do a lot of this work myself, like as a client, like a lot of smart people, let's say a corporation, somebody says, okay, I want to do a lot of the work, like I want to understand a lot of this myself and then come prepared to a lawyer. How much of that would you say? So the main question is like when to go for litigation, when not to go for litigation, maybe settlement and other routes that you feel are feasible. And then the other one is like when somebody says, hey, I want to do a lot of this work myself, right? Like when do you feel it is maybe a good idea and when you think, no, this is definitely not a good idea?
Well, and I want to be respectful. I really want to be respectful, and I could sit here and say it's never a good idea to do anything on your own. Would you do dentistry on your own? Would you fill your own teeth? Would you would you operate? Would you remove a mole on your own? Some people say, yeah, I would, but I don't think that's a good idea.
Yeah.
And I'll say this, that oftentimes when clients come to us, it's because they have been unable to resolve an issue, right? So they get to, again, when I say my firm is a litigation firm, what that means is that, we're a last resort because they couldn't resolve the problem without talking to us. But I got to admit, though, that our first step is to say, are we able to engage the other side with a letter, a demand letter, with a letter that says, look, we think we're entitled to this, or we think you're wrong in the claim you made against us. Here are the reasons why, and is there a way to resolve it? So that's part one, engage the other side. So our representation doesn't mean we're going to go to trial and file a lawsuit. So first we're going to reach out to the other side and see if there's some middle ground here. And that's part of the risk assessment, right? If we go to trial, how expensive is it? How long does it take? What's the likelihood you're going to win or lose? So that's part one. Part two, if the other side is like, if there's still a disagreement, you may want to get them to say, hey, would you be interested in some kind of alternative dispute resolution? So we have resources available to us and relationships we've built with certain organizations where they can serve as neutral mediators, oftentimes involving retired judges or people who have, who are trained in the mediation process. And what you got to tell your client in that regard is you're not going to get everything you ask for. The mediator is going to try to reach some middle ground, but it's going to be quicker, and it's going to be less expensive for you in the long run. Okay, so that's the second option. And then if that doesn't work, you finally say you have no choice. You can ignore it. Now again, can they do it themselves? I do not think that. Every once in a while we have cases where individuals have represented themselves in court. It's been a disaster for them. It's a disaster for them. Okay, they just don't understand the rules of evidence, the requirements by way of the Code of Civil Procedure. They don't understand. When I was a young lawyer, one of the first cases I tried in front of an attorney, it's a small property damage case for one of our clients, and the plaintiff said, he was representing himself, that he said, your client ran into my vehicle in the company parking lot and then drove away. I said, well, did you see it? He said, no, but a colleague of mine saw it. Okay. And then I said, well, what are your damages? And he had an estimate for $4,500 from the repair shop that he wanted my client to pay. So the judge says to us, go out into the hallway and see if you can work out a deal. And I said to him, after knowing this, I said, you're not going to be able to prove your case. So I said, I think you need to, what are you talking about? Da, da, da. So he gets, we can't settle it. And he gets in front of the court and he tries to say, my colleague said that he saw the defendant run into my car and I objected and that was sustained. And he looked and said, what happened? He goes, you can't provide testimony about what somebody else says. And then he says, but I didn't know that. I said, well, you should have known that. We're not going to do your job for you. You should have known that you have to call the witness to give the testimony. Yeah. So then he says, what else do you have? And he goes, well, I've got this estimate. Objection. Well, what's the problem? He goes, I said, it's hearsay. He goes, well, what does that mean? And the judge says, sustained. So this individual thought it's simple. I'll just tell my story and the judge will find in my favor. And as you can imagine, he walked out of that courtroom without any recovery. Now that's a small example, and and they think you can do it, but you got to know the rules. You got to know what's allowed, what's not allowed, and there are reasons for that. And we spent 3 years in school, at least after our undergrad degree, to learn that. So I don't know. I know. I mean, we oftentimes have people come in who I wish they would have spoken to a lawyer differently or before they came to us. We would have saved them a lot of time and money. And it's hard for people to know that. They're trying to not spend the money because most business owners or individuals, this isn't something they budgeted for in the year. They didn't know they were going to have a $10, $20, $30,000, maybe more legal bill. And it's really affecting, and we get that. We try to work with clients in that regard, but the outcome is worse. The outcome can be worse without the assistance of counsel. Yeah. So I can't imagine in any type of moderate or high-end litigation you would ever represent yourself. First of all, you can't.
Mm,
right? You understand that unless you can represent yourself as an individual, you can't represent a company. You got to be licensed.
mm,
You have to have your license, and a corporation cannot be represented typically by
mm,
their officers or other individuals. They have to bring in an attorney.
mm.
Um,
Yeah.
so I look. You might be able to do your own will. You might even be able to do your own divorce if there aren't a lot of things to disagree about. But short of that, and
Yeah,
I wouldn't
I have a
recommend
lot
it
of
to
family
you.
lawyers on this, so I don't think you want to do your own divorce or.
I don't either.
But
I don't either. And there's so many, like, even if it's an amicable divorce, which sometimes they occur, and the parties agree, like, this isn't working out, let's just split stuff, and and maybe there are no kids, or they can agree on the kids. We have like certified mediators at my firm who can mediate that case instead of having to go to court. That's why it's what did we talk about at the beginning, Syed? We talked about setting expectations as to time, cost, and outcome.
Mm,
Those are the expectations you're setting.
mm,
If people already have it made up, have a lawyer look that over. It's not going to cost you enough money, but it's going to be binding and valid, and you'll be able to get on with your lives. We're also doing things like trying to reach out to some corporate clients kind of on a pre-litigation matter and tell them the things that they need to look out for to manage their business and to make sure that they don't get in a position where, and sometimes it isn't just with your competitor, with your employees. Are you paying them properly?
yeah.
How are you, what benefits are you giving them? Are you applying it across the board? Things of that sort.
Labor and employment, especially in it's a sidetrack, especially in the state of California, it's one of the highest litigated states when it comes to labor and employment, wage and hour. Like it's to the point where the I think it's called PAGA, is the name of the legislation, and if anybody's here from California knows this, that the government takes more money when you win than the actual person who won the case. So it's the government wants you to litigate against your employer. I mean, I'm
Yeah.
not saying that that's what they're doing, but that's kind of like what I read from or understand from this, and I'm like, yeah, this is gone really strange. But anyway, that's just a side note. But to your point, basically, if I want to distill this, you're gonna pay now or you're gonna pay later. When you pay later, you're gonna pay what you were supposed to pay now, plus whatever you were not supposed to pay, plus whatever time and effort that you could have saved if you did some upfront work. Whether you take the service or not in the beginning, but at least you have an expert opinion. And I totally agree with that, like the doctor analogy, that you need to understand, like, you're not going to extract your own teeth or do your own fillings. I mean, you might want to try, but not at your own detriment, right? And that's kind of like, I totally agree with that. Let's talk about the future. So you started, you said 33 years back. You did certain things to do research before. You've seen kind of like the 90s, 2000s. Now we're at a very strange phase where we hear of AI and ML. And there have been cases now where somebody's been disbarred in the state of New York because they went to ChatGPT. They actually got a case from ChatGPT, and it was a made up case. And they presented that in court. And then people in the court were like, what year was this? And they started asking questions. And the opposing counsel actually did research, and he said, I don't find this anywhere. Like this case, this person, this lawyer is talking about is, I'm not able to find it. And then they found out that there is no such case. And then they said, okay, what's your evidence? And then he said, this is from ChatGPT, and this person was disbarred. I mean, I'm just saying this is the worst case scenario. But
Right.
like from a litigation perspective or from a good lawyer perspective, what would you say is what you feel is now the use of technology? What would be a good lawyer? How are they using technology now? Obviously for productivity. How do you see that kind of like changing as well in the next 5, 10 years? Now we're making fun of ChatGPT and AI ML tools, but would there
Yeah,
be?
it'll get better. It'll
Yeah,
get better.
it's getting better, but like, what is your take on that? Like, what is?
So regarding Chat GPT, I beg your pardon. It's not, that's the problem with it. Even though it's going to do certain things, we've been told that it follows patterns. It doesn't confirm accuracy. If I understand how it works, it just predicts. And my son is a computer science and interactive media expert or college graduate. And I asked him, I said, what's going on with this? He's doing some artificial intelligence work for his employer. And he says, it's not, you don't worry about it, he says to me, because all it does is it predicts, it doesn't even predict like a conclusion like we talked about, it predicts the next word almost. And obviously, we've all heard that it really does make things up. So you can't use it at your peril. If you're using ChatGPT to cite legal authority, you're going to have a problem unless you check that legal authority. Now, could it give you some sense as to like maybe how to craft the document so it's more effective, it's cleaner, it sounds better? Yeah, but I don't think you can use it to be authoritative, and you cannot use it to be authoritative. So you have an obligation, and that's why this lawyer got in trouble, because he probably claimed he did something. He did something that which he didn't do, right? He presented something to the court that he never bothered to check, and that's a big problem. So the other analogy I'll use in that regard, Syed and everybody, I've done work for insurance companies for my entire career, and we were always, people getting in motor vehicle accidents and collisions. And we've been told going back 15 years ago, there's going to be self-driving cars. The cars are going to drive themselves. And then once they drive themselves, you're going to be out of business because the cars won't run into each other because there'll be some force field that prevents them from running into each other. Well, I'm like, okay, but that's not happening, right? Even, the Teslas that are self-driving, one of our attorneys just bought a Tesla, and we went out for a Chicago-style hot dog recently. And he says, this thing could take us back to the office I just punch in the stuff. So I said, all right, go ahead and do it. So we're driving, 3 lawyers in the Tesla driving back to the office. I said, Doug, are you driving the car? And he says, no, not really. I don't really trust it. So he says, I said, is it self-driving? He said, no, I don't trust it. I'm driving the car. I said, well, that's the status of the technology. And so I think ChatGPT is the same. Now, if it does get better and it can be used, I think you have to be nimble in the practice of law. The one thing that I have seen technology impact over the years is like, for those of you who are new to the practice, you've always researched your cases on Westlaw or Lexis or some other database. And you use your keyboard to find the authority you need to cite in your briefs. Well, the joke now is every time we see a website with lawyers standing in front of, we used to all have libraries, right? We used to have to go into the library and pull a book and copy a case on a photo machine, on a copy machine. That doesn't exist anymore. As a matter of fact, they're giving all those books away to theaters and to studios so they can put them, when they want to make an old period movie, they can put all the legal books on shelves in it. But nobody uses books anymore to obtain the information that they need for purposes of citing their cases. The way we handle documents, we're a paperless office. There's no need to have any paper anymore, other than if you want to preserve something for some, rules of evidence or chain of custody. Everything is digitized. Nobody would say, well, and you got to be careful with that because things can be manipulated, but so could paper. Paper could be manipulated. Anything could be. It's not the technology. So what we're finding is that you need staff and you need attorneys who have those legal skills, the technology skills, because that's a huge part of every industry, not just the practice of law. How we manage paper, how we search documents, how we summarize documents, how we're able to find items in our paper. That's a big part. And the way we produce work. Now, the lawyers are all very proficient in typing their own. When I first started, all the old-timer attorneys, when I was a young lawyer, couldn't type. They would write things out, and their secretary would have to type them. And then we got into dictation. They knew how to dictate. They couldn't type. They couldn't use phones. They couldn't use digital phones. So that has changed. So you got to be ready for those changes and try to incorporate technology that makes sense. But at the end of the day, Syed, the practice of law, in my opinion, at least in litigation, is a human experience. The idea of what we want as human beings when we interact with each other, whether it's a story, we want to feel good, we want to feel that we can trust the individual speaking to us. Technology can help in that, but it still has to come down to communication between two people.
Yeah, no, totally agree with that. Like technology is a tool. It's not going to, when they say replace somebody, it's like if you're doing work that can be replaced, God bless you. Like, what kind of work are you actually doing? Because initially when the marketing of this came out, it was more like, this is going to take away jobs. I think the jobs are going to shift, but taking away jobs, I mean, there will be more jobs created and things like that. But I totally agree with that. Like research, like the big takeaway is the way research is done. But then again, the lawyer has to recheck based on, because ChatGPT, like if it's just something which searches a big database and comes up with whatever is in that database, it's perfectly fine. But if it
Right.
starts making up stuff, which is more scarier, then the lawyer is liable basically for citing something that they said is legitimate, right? Like you can say that, oh, I trusted the system, but why did you trust it? Do you know what it actually does? Like, would you trust something that you don't even know is making up, I think that's really the scarier part of this. And it doesn't understand, like you said, artificial intelligence not understanding, they're predicting the next word. So it doesn't really understand like a human. I guess we have a way of understanding or correlating things. So it's a little different in that way. So last piece of this is, if you were to go back, like what would you tell yourself coming out of law school that you felt like, okay, if I knew this, I would be, I don't know, 10 years ahead. Like if somebody had told me, or if something that you may say from maybe a training perspective, something you may say from a mentorship or guidance perspective, because that's a question that comes up because a lot of lawyers, when they, I hear this a lot from younger lawyers. It's like, I didn't know billing requirements was such a thing. Like I have to do billing. Like this is such a thing here. It's like, yeah.
Yeah. So I don't think it's anything. Depending on the practice area, the first thing is when you're a new lawyer, you just don't know. Some of us, I knew I always wanted to be a trial lawyer, and that's what I've done. And there was no doubt in my mind. I've had some early experiences that confirm this is what I want to do. But many of the young lawyers out there are still trying to figure out what practice area do they want to be in for their career. And I don't think you can do everything well all the time. I think you have to probably pick an area of concentration. And so the sooner you could understand what you want to do and understand what that requires and what it does, it do you bill, do you not bill? If you work for the government, you're probably not billing, right? You work for a corporation, you may not bill the same way an outside attorney might bill, but maybe you track your time, but you got to communicate more meetings. So you got to figure that out. You got to figure out what practice area interests you and what can you get passionate about or interested in to do when you're working. But the most important thing is that whatever firm, organization, government entity you work for as an attorney, you work on your own. Well, if you work on your own, this won't apply. But if you work with a group of lawyers, you should start being comfortable with giving your opinion. If giving an opinion that is based on information you've acquired. I struggle sometimes when I meet with young lawyers. I say, well, this is what I think. What do you think? What's your impression of this? Don't underestimate, don't underestimate the ability of especially a younger generation of having a different perspective on legal issues that we see all the time. I may feel about them one way, but I'm approaching my 60s. If I'm approaching my 60s, I see the world differently than somebody in their 30s. And I want that insight and say, what do you think of this? What do you think of that? So it's a combination of having a well-informed opinion, okay? And then the second part is developing your judgment. The sad truth is that if you want to be in a profession where 1 + 1 = 2 and 2 + 2 = 4, this is the wrong profession. You can't have that level of certainty. This isn't finite mathematics. It is. So therefore, it's going to require you to give an opinion, and it's going to, and sometimes, you have to be able to continue to develop your judgment and whether you should do this. So the analogy again that I like to use is you have a lump on your forearm, and you go to a doctor, and the doctor says, well, we think it's a tumor. God forbid, think it's a tumor. And I think what you ought to do is you could take medication, or you can do radiation, or you can do surgery, or you could just leave it alone. Those are your four options. Tell me what you want to do. And then the doctor sits back and waits for you to tell him what to do. I think lawyers approach the practice of law that way. They give their client a bunch of options, but they don't develop the judgment to say, but however, I believe here are all your options, but this is the best. This is under this information, under this set of circumstances, I recommend you do this. Don't tell me what I shouldn't do. Tell me what I should do. Like, what should I do? You know, and my best experience has been when I've had when I've represented people who are, you know, my mother's age, my sister's age, my somebody who's close to me, and they have an issue. I oftentimes think to myself, if this was my sister, what advice would I give her? Somebody that I care about, that I want to do. If this was my mother or my father, what advice would I tell them to do? And I tell them that. I say to them, look, it's your choice, but if this was my family member, or this was my, you know, company, or my parents' company, it's not perfect, but this is what, and lawyers are afraid to do that. And they probably say, oh, what about all the stuff I don't know? I get it. But when you tell them why they should do it, just make sure you have some reason why you have that opinion, but tell them that opinion and make the choice on behalf of your client the best that you can under the circumstances. And then when you come up with that opinion, check it out with your colleagues. Go down the hall and tell your, you know, don't go into your partner's office and say, what should I do? Say, I have this issue. I came up with this solution. What do you think? Nobody at the high level of your law firm wants you to come in and dump an issue on their lap. They want you to think it through, and then give them what you think the answer is, and then they could say, well, have you thought about this? Have you thought about that? What about this? How would this impact that? That's what we want. We don't want to say, I've never done this before. Tell me what the answer is. And, you know, it doesn't work like that. You've got to make the effort to educate yourself, to start giving your judgment and opinions to your clients.
That's money right there when it comes to that. Like, I totally agree with that. It's just like going to a car mechanic and saying, and they give you a bunch of things like, oh, your axle, it's a little loose. What I would do is, you got three options. You leave it, you fix it, or you can replace it, and then it's up to you. It's like, okay, like, tell me what I gotta do. But yeah, though I totally agree. And I think because we're such as a society, I think that portion has overall a level of expertise. Like, people know a lot more, but the judgment has gone down. Like, I totally agree with that sentiment. Like, overall in the States, like, just overall, like, if you talk to an expert, they can tell you all the information, but there's no like, hey, what would you recommend? What is a recommendation? I don't want to know what you know. I want to know what we can do with what you know, right? Like, I don't want to know everything you know. I just want to know what is the best route to take here. So yeah, you're the expert guide. It's like going in a jungle, and then the guide is basically saying, okay, what options should you? It's like, hey, you're asking the wrong person for options here.
And then your client may disagree with you, right? They may disagree with you. I have a colleague of mine that has a poster on his bulletin board, and he says, don't confuse your Google search with my law degree. You know, because now everybody, they think they know the answer to these questions. And I think that's true. You can't confuse, your client's Google search about what they should be doing with your law degree.
And I think the other way of saying this is that, Google is a search engine, but it does not give you the judgment based on the information you're telling me that I've seen myself play out. Like, what Google is saying is probably 100% true, but Google is not going to represent you in a court of law. You can't just, like the person you litigated against, or like the person who was, you brought up certain things and they were like, yeah, this is the end of the trial. And the guy's like, I didn't even know that. So yeah, totally agree. Perfect. Thank you so much for your time. This has been a super value add. Thank you. And we will definitely post this on YouTube as well.
Thanks, Syed.
All
Thank
right.
you.
Have a great day, everybody. Take care.
Bye-bye.